Well, hello everyone, and welcome to Uncivil Law. I hope you're having a great day. For today's story, we're going to be reviewing a response from Denims in the ongoing H3 Ethan Klein lawsuit. For those of you who forgot, H3 Ethan Klein did a whole content nuke video, which was designed by him apparently to try to entice people to react to for the purpose of potentially filing a lawsuit against them, which itself, of course, is not a problem, right? Because you don't really blame the victim. This might be slightly akin, although the analogy is not quite perfect, but it might be slightly akin to like taking a really nice car and like leaving it with the motor running and the doors open and the key inside in a bad part of town. Is this necessarily the greatest thing to do? Probably not. But does it excuse the person who steals your car? No, right? So, he might have been baiting them, but, that itself isn't illegal. And apparently they took the bait, and it's not necessarily going super duper great. And Denims, for her part, has filed a whole bunch of defenses, none of which really work. And we're going to discuss this really fast. So, of course, she first of all files an answer. She hasn't filed a motion to dismiss yet. She could file a motion to dismiss at a later time. 12b6 can be filed at a later time. But she apparently is ready to go forward on discovery, which seems like a strange choice to me. Because, well, if you just give an answer, you can file the motion to dismiss later. But you're basically like saying by answering, it's like the next step in this is discovery, which is good if you want to speed things along, but not so good if it's a choice Denims is making, a questionable choice, but okay. Anyways, so she's like, I'm ready to go to discovery now. Okay, so it's super fun. All right, so we have the affirmative defense of failure to state a claim, which is 12b6. She hasn't actually filed 12b6 yet. Failure to state a claim is 12b6 on a motion to dismiss, but she's just saying it as an affirmative defense. She doesn't really need to say this, like, for any reason, because, she can basically move to dismiss at any time, right? If you get to the end of the trial and you haven't made your case, you can always move to dismiss, right? So she doesn't really need to say this, but she's going to say it out loud anyway. Like, okay. So you think that he's failed to state a claim? Okay. I'm pretty sure he has, but all right, fine. All right. Then we got fair use doctrine, which Denims does not go on to explain. Fair use doctrine has a 4-factor analysis. We've gone through it before. She basically fails every single factor repeatedly, and then by her own admission, by statement, she not only does she fail all 4 statements, all 4 factors inherently, but by her own statements that she's made on media and on screen, has basically like blown apart her defenses, in particular the idea of market substitution. So the idea that like her work is not a substitute is kind of blown apart by her own statement saying, yes, please come watch with me so you don't have to watch and pay him, and so forth and so on, right? So her own statements kind of shoot her fair use in the head, particularly with respect to market substitute. So, good luck with that. You kind of fail every factor. And although the fair use analysis does allow you, because it's non-exclusive factors, so you can literally point to that 5th factor. It's not listed in the statute, but you can always try the 5th factor. Good luck finding one, right? Good luck finding the mysterious 5th factor. I'm sure it's gonna definitely save your ass, particularly when all 4 listed factors go against you. But never fear, you'll find that 5th factor, I'm sure, and just make it work. Good luck. All right, great. Now, this one, express license doesn't really work. Express license and implied license are kind of the same thing are twins of the same thing. A license is just permission, right? When you give someone a license, you give them permission. That's it. So an express license is me saying, yes, you can do the thing. An implied license is me not saying it, but it is implied by circumstance. So if you buy a movie ticket to go watch a movie, that is an express license, right? Because you bought the ticket, you're now holding it in your hand, right? And you go watch the movie. You have permission by the movie theater to go in there and watch it. right? And that's a license. You're a business invitee, taking advantage of the business with your ticket in hand, as you do, right? So that would be like an express license. I buy permission, you give me permission. An implied license would be derived from the circumstances. Now, express license doesn't really work because how is she going to point to how H3 gave her express permission, right? In order for her to prove express license, she'd have to be like, he said it, or he wrote it, or there was a sign or something, right? It would have to be express. And how's she going to do that? She doesn't. Implied license is kind of interesting, but I think doesn't really work here. So implied license is the idea that you have permission from the set of circumstances, or a reasonable person might think that you have permission from the set of circumstances. So again, this is kind of akin to the idea of, leaving your car with the, leaving your car, your really nice car in the bad part of town with the door open and the car running and the keys inside. Is that imply permission for someone else to drive your car? Well, probably not, but at least there's some idea there that somewhat makes sense in some universe. But the problem for Demis and everyone else is, to the best of my understanding, Ethan Klein had sent like cease and desist notices with respect to previous instances before. So this is the idea, it's the idea basically like I had permission in the past, so I assumed I had permission now because there was nothing telling me otherwise, right? I've crossed your field 100 times, and so I thought I had permission the 101st time, right? That would be like an idea, and you didn't do anything to warn me. But here, it seems like he did things to warn them. He seemed to give notice to people that he didn't want them doing this, and they did it anyway. And also, their own rhetoric, when they were streaming it, didn't seem to imply that they thought they were doing it with his permission. So again, like their own statements are going to be a real problem here, right? If they had not said things on stream and they had just done it, this would be a more colorable argument. As always, their own words are going to be a major factor against them, right? They didn't act or say things in a way that represented that they thought they had permission, right? They didn't say things like, oh, this is totally cool, and Ethan Klein's totally cool with it, and this is all fine. They seem to, in their statements, be actively aware of their lack of permission and gleeful in their lack of permission that they could take away from him. So their own statements will, if nothing else, contradict the implied license, because, of course, for the license to be implied, I would have to understand that I have a license, right? If I believe I have an implied license because of things you did, I have to actually believe that. If I don't actually believe that, then how is it implied? Because if I didn't infer it, then it doesn't really matter, right? So their own statements, as always, are going to be a kick in the pants. So if you were trying to do this without their own horrible, self-defeating statements on the page, this might be able to get somewhere. You might be able to make, for example, an implied license argument with respect to YouTube in general, or maybe social media in general, because there is kind of a sharing culture. So maybe you can make some sort of implied license because of the way that people typically behave. And this is not an completely invalid concept, because when you're thinking about anything, you think about it a lot in the context of the norms of the trade, right? So when you're thinking about what is an express license and you're thinking about what is an implied license, that is strongly informed by the nature of the business or trade or the norms of what you are doing. So if people within the scope of the work as a whole tend to share and share alike, then that might be understood as a sort of, thing in general, as opposed to if everyone's very closed, that might be understood as a thing in general. It's not like that someone can't express something different. It's not like just because you join the group, you're necessarily giving permission, or you can't take away that permission. It would be somewhat similar to the concept of like what battery is as a tort. In most states, for example, you have this idea of the touching not only being subjectively unwelcome, but also something that society is prepared to recognize as being a limiting factor. So one of the sort of the key things I sort of use to illustrate the point is like, let's suppose that your back is to me and I like just tap you on the shoulder to get your attention, right? That would probably not be battery in most jurisdictions, because me just doing a light tap on your shoulder to get your attention would not be, even if you subjectively didn't want it, unless you had communicated that to me again, right? Because you have the right to define your own boundaries for yourself. So if you had communicated to me, or I knew somehow that you didn't like it and I did it anyway, that would be battery regardless of society, right? Because you have permission to define it for you. But if I don't know anything about you in particular, and this is societally acceptable, which is the premise of this thing, then, you know, me doing this to get your attention would not be considered battery, because even if you subjectively don't want it, it's not the kind of touching that society would be prepared to recognize as something we should do about. See, for example, like brushing someone, you know, like we're in a tight hallway and we like, you know, we brush by each other or something, or, you know, other comparable examples to this, right? So one of the things you're thinking about in the idea of an implied license in particular is what is true in the industry, trade, circles, community that you might float in, right? So the idea of implied license might, for example, get you a little bit further than it might within YouTube or within social media or within reaction content. It might get you a bit further than it might in some other contexts, you know, depending on a whole bunch of factors. But it's a more viable argument, perhaps, in creator communities than it would be, for example, in industry communities. However, that being the case, one, Ethan Klein seems to have communicated he didn't want that through the previous cease and desist. So that's like a clear signal that he doesn't want it, regardless of what the community as a whole wants, because again, he has the right to define for himself as long as he communicates that. And two, even worse, they by their own words, actions, behavior indicated that they did not believe that they had a license, right? If I believed I had permission to tap you like this on the shoulder, right? And so I was at, you know, with you at a party, or this is like, even if I don't know you, right? Even if I don't know you, but I want to get your attention. I did this to get your attention and like went on about my life, and I was telling someone about it later, I'd probably be like, oh yeah, you know, I went to go see Bob. He's a famous writer, you know, and I couldn't, you know, resist the temptation, you know, to try to talk to Bob. You know, it was a once in a lifetime opportunity, and I did this, you know, and, you know, Bob didn't want to talk to me, but, you know, I was thrilled just to be there. I might say something like that. I'm probably not going to say something like, you know, I really got one by him. You know, I went up to him and, you know, did this, and I, you know, with all the villain mustache twirling and so forth and so on. So their own words really are a kick in the pants for their implied license. So implied license might get you somewhere in a normal lawsuit in this domain. With respect to their particular lawsuit, probably not as much. No. Denims. Okay, denims. I'm sorry, denims. I will correct it. Denims. I apologize. So yeah, maybe in some version of this lawsuit, but not so much right now. Okay, unclean hands. This is equitable doctrine, right? This only really works in equity. It doesn't really work in law. And Ethan Klein is principally making a copyright lawsuit, which is not equity, it's law. Unclean hands is an equitable doctrine. You can't come into, it's not really much of a legal doctrine. And also, what unclean hands? It's literally just, it's literally conclusory. It's just, this is horrible. The claims are barred in whole part by the equitable doctrine of unclean hands. You know, you do realize that you just can't say things, right? You do realize you just can't say unclean hands like it's a magic words. How? And as they themselves write, it's an equitable doctrine, which works in equity. But Ethan Klein's lawsuit isn't principally in equity. It's principally in law. So, yeah. Okay, great. Waiver. Okay, so somehow, some way, waiver is the idea that you did it bad against me, but I excused it, and now I can't go back on that, right? Because I forfeited my right to it. So an example would be like, let's say you owe me $500, right? And you owe me $500, and you come to me and you say to me, I can't pay the $500. And I say, don't worry about it. It's not that important. Just don't worry about it. It's fine. Right? And you go off and then I later sue you. Right? I can't do that, right? I can't like waive my own cause of action and then revive it, right? Because like that doesn't really work. So somehow, some way he did something to be like, you've harmed me, and then be like, oh no, it's cool. When did he do that? When did he do the oh no, it's cool thing? I don't know. No one knows. Pressing on. Estoppel. We're just throwing random words at the page now. Isn't that what we're doing? Someone somewhere gave this lawyer a copy of a blue book or Black's Law or something, and we're just throwing words at the page now, aren't we? Is that what we're doing? Pretty soon we're going to have the affirmative defense of corpus delicti and sovereign citizen. Who gave this lawyer a thesaurus is what I'm trying to say right now. Okay, estoppel. All right, fine. So estoppel is a principle basically where I can't do this anymore because of my own actions or because of a court action that has prevented it from working. Like, it's this idea of I've already had one bite at the apple and I've lost, so I can't come again, or I've taken an inconsistent position somewhere, and so like it's not so much that I waived it to you specifically, it's more like I've taken an inconsistent position in a different context and I can't have my cake or eat it too, or the court has ruled against me, or I don't know, just like you know, it's like you said this over here, so you can't say something different over there, collateral estoppel or something like that. What's the estoppel supposed to be? There is no clarification. Again, it just says there's estoppel. Like what? Would you like to clarify that at all? Would you like to tell me more about what the estoppel is? No? You wouldn't? Great. Okay, moving on. Justification or excuse? All right. Well, I guess I'll spend some time telling you about the difference between justification and excuse so that we can learn something. Not that it really matters, but as long as we're here to try to learn something of legal value, I will tell you about the difference between justification and excuse, because there is a technical difference that really only lawyers care about, and even then, not really, but I'll tell you about it anyway. All right. Excuse, technically, would nullify or cancel an element of the crime, typically the mental state. Justification is, yeah, I did the thing, but I had a really good reason. Okay? So a typical self-defense, for example, would be an example of justification, right? Yes, I did the murder, but I had a good reason, right? It's like, yes, I did all the things. I met every single element of the homicide, with intent, with intent, I killed the guy, he's dead, right? All those things. I did all those things, but I had a really good reason, right? And self-defense, like he was threatening me first, right? That is justification. So, yes, I did the crime, but, okay. Excuse technically means I didn't commit the crime. And so it's an attempt to like nullify one of the essential elements of the crime. For example, if I did the crime because I was coerced, okay? Classic, is this a classic scenario? I don't know. A scenario, bad guys are holding my family hostage. They've got, they've got weapons pointed at my wife and child, go rob the bank or else. Save us, daddy, save us, right? Okay. So yours truly goes into the bank and robs the bank and is arrested in the process of robbing the bank. Okay. My argument isn't justification, right? It's not that I robbed the bank and I had a really good reason. My argument is excuse. I didn't rob the bank at all, because in order to rob the bank, I have to do so with the intent. I have to, with intent, go in and blah, 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 blah. And I didn't have the intent because my intent was coerced, meaning it wasn't a free choice because of the bad guy, right? So that would be an example, whatever. And so, okay, so they're trying to argue justification or excuse. First of all, I'm not really sure what justification for copyright infringement would be. What would that even be? That's great. Okay, let's dream it up. This is going to be good. Let's see if yours truly can. And I'm an IP lawyer, although principally in patent law. But let's see if yours truly can dream up a plausible justification for copyright infringement. Not really. Yeah, I'm having a tough time. The coercion thing would work, I guess. Okay, I'm doing the copyright infringement because the bad guys are threatening my family, and instead of them wanting me to go rob a bank, they're saying, please download Disney's Beauty and the Beast and play it for us. And if you don't, we'll kill your family. I guess that's excuse, I suppose. What is justification in a copyright claim? I don't know. I got nothing. Maybe someone else can come up with something. So I'm not even sure what justification would be, but I appreciate their enthusiasm. All right. Ninth, affirmative defense, consent. Well, that's just the same thing as license, to be quite honest. I mean, consent is license, so, Innocent infringement. All right, well, that doesn't really work as a defense in copyright because it's a strict liability offense. Now, if it's truly innocent, which it's obviously not, but if it's truly innocent, I believe the minimum damages for a statutory violation for copyright, I want to say it's like $200 is the minimum for a truly innocent infringement. First of all, it's not a complete defense. Second of all, it absolutely does not apply here in any way. See, for example, their previous statements that they made to, buttress that point. I don't really have to sit here and explain it. No, but we appreciate your enthusiasm. Just no. 11th affirmative defense, no injuries or damages. Well, the thing is, when you're talking about statutory damages, they're statutory. That's why they're statutory damages, right? You don't have to prove damages. They just are. Because the statute created them. So, like, what damages do you claim? Well, the statute says I win. Oh, yeah, okay, so you don't have to prove any specific injury. You just be like, I win. So, okay, that's exciting. No injuries or damage, no one cares. Good faith. Okay, well, good faith sounds a lot like, I thought it was okay. It sounds a lot like implied license to me. See, our previous discussion on implied license, particularly relevant to their own comments. Inequitable conduct. Again, like what? This is just like, we're just saying things. And also, again, it's inequitable conduct, which only really applies to equity because it's right there in the name. It's inequitable conduct. If we are bringing a lawsuit in equity, but we're principally not. We're principally bringing it in law, not equity. So this defense, first of all, no, it doesn't apply. And even if it did it, so first of all, it doesn't apply because we're not suing in equity. Second of all, even if we were, what inequitable conduct? You can't just scream equity. That's not how it works. Equity has actual like causes of action. It's not just some like magic label. It's not, maybe they're confusing it with like the leftist version or the leftist idea of like equity, right? Maybe they're confused about what it is. Maybe they think it's like when the leftists talk about equity, it's nothing like that. It's nothing even close to anything like that. It is not the leftists. When they say equity, that's not what they're talking about. Equity has been around for like 500 years. It's not new. No. Unjust enrichment. Plaintiff would be unjustly enriched if allowed to recover to the extent. How? How would he be unjustly enriched? First of all, once again, I'm getting tired of saying this. I really am. Unjust enrichment is a defense in equity, right? It isn't fair, right? I mean, it's unjust, right? I mean, it's literally, this isn't fair. It's a theory in equity. Why? First of all, why? Second of all, no. Because again, we're not suing in equity, we're suing in law. I'm not saying like I've been harmed or wounded in some abstract sense. I'm saying statute apply, yo. Give me money. What are we doing? What are we doing here? I don't. Laches. Well, that's particularly rich, particularly in copyright law, because the Supreme Court explicitly rejected that quite a long time ago. Well, it's not that long ago. It's like, I don't know, when did they get rid of laches in copyright law? That's been a while, though. 5 years, 6 years, something like that. They got rid of, it's been a hot minute. As long as you're suing within the statutory time frame, which is 6 years, and he's well within that, so laches doesn't apply. So just no. And even if the Supreme Court hadn't said that, laches still wouldn't apply. Laches is just basically you've sat on your rights too long. He sued right away. He couldn't have been more efficient if he tried. Laches basically it's unfair because you waited too long. How's that supposed to be a thing? I don't know. So first of all, it doesn't make sense. Second of all, the Supreme Court killed it a couple of years on copyright law. So no. Okay. Failure to register copyright. Well, he said he did. Lack of notice. He doesn't have to give notice in advance. That's not how that works. And reservation of additional defenses. Okay, and therefore you want to dismiss with prejudice, although you didn't actually file the motion to dismiss, so no. The plaintiff take nothing, and you want attorney's fees, no, and grant us such other relief. Signed by Benjamin Caius and Benjamin Grush for Alexandra Marwa Saber, also known as Denims, from Frost LLP. Frost, I'm not particularly thrilled with your defense. I know that you don't believe in any of this. I know that you don't believe in any of this. You just threw everything at the wall. I don't blame you for but you just threw everything at the wall. I don't blame you, but that's all shit. I assume they know it's all shit. They're not idiots, I hope. They just basically threw a general denial. They just basically said we deny everything, and then also here's a whole bunch of defenses that don't really apply. Okay, well, exciting. All right, well, things are not looking good for Miss Denims in this lawsuit. None of these defenses really work. Largely, well, first of all, half of them don't work because we're not in equity. So someone needs to give them that memo. We're actually not in an equitable cause of action. So half the defenses don't work because we're not in equity. So there's that. And the other half don't really work because of our own statements in significant part. So things are not looking super promising, in my humble opinion. I can't help noticing they didn't file a motion to dismiss right out of the gate. So that's not necessarily feeling like they feel like they have the strong hand there. Yeah. Didn't even bother to file a motion to dismiss. Woof. Yeah, it's not going great. If they didn't register for copyright, they can still sue for damages. 100% that's true. Yes, they can. They just can't get statutory damages. That's true. But if they didn't register, yes, they can. They just can't get statutory. True. But I believe he did register, so the issue's moot. I'm going to change the name of the title real fast before I forget. It is 3,000 degrees outside right now, by the way, in Texas. I've had the hottest day, man. I feel like I'm on the surface of the sun. Is there anything else before I sign off on this? You have to sue before infringement? No, you don't. That would be impossible. How could you possibly sue before infringement? That doesn't make any sense. How do you sue for copyright infringement before the copyright infringement? How does that work? No. When a storm is brewing, I've noticed. Yeah. I think he's being facetious. Fair. Yeah, it's like how do you sue for copyright infringement before the infringement? That's not how that works. I'm still going to try to make it to the gym today. I was out and about, and I thought I was going to die. So I was waiting for it to cool down a little, but woof. All right. Well, Ethan Klein, long story short, Ethan Klein's case is looking pretty solid. Am I going to cover Donna Adelson? Probably not. I'm trying to make my video on demand thing work. So I'm not really eager to jump back into a live stream. Still trying to make the videos on demand work. So probably not. But, maybe I'll give openings a try and see how it goes. We'll see. I don't know. But yeah, probably not because I want to see if we can make the VODs work. We'll see. All right. I'm going to sign off for now. I hope you had a good one. I'll talk to you later. For now, cheers and goodbye.